All right. Hello, Var. Thanks for joining me today. We're doing our weekly sort of PL legal discussion. We're going to talk about a client who we helped remove squatters for. We're actually still in the process, but it's quite a straightforward process in some cases. So we'll talk about things you need to be aware of, what's happened in this case, a couple of things we got to overcome for her. And then obviously, if you've got any questions just related to how we go about it, or if something's not clear, just jump in anytime. All right.
Got it.
Okay, great. So in this case, the client has a family home. It belongs to her father. They've moved to the UK, and then her father's moved back to Nigeria. They've gone on holiday for a bit. So while she's typically in the UK, London area, she, for the last, I think it was 8 months or so, hasn't been in the or not hasn't been in the country, but hadn't been to their family home. And during that time, some squatters had taken occupation of the home, which it turns out is actually quite a common occurrence in the UK, believe it or not, especially based on how clearly defined this process is. Normally, you've got a couple of options because it is a criminal offense to live in someone else's home without their permission. You could go straight to the police and just have them removed. Sometimes people don't want to involve the police. Other times, it's more case of the facts aren't extremely clear. So in this case, they have asked the squatters to actually leave, but the squatters have claimed, well, we've got a tenancy agreement in place. They've provided a document between themselves and a landlord who has supposedly been charging them rent. They've been paying that rent in cash. They've not been paying any utility bills. They've not been paying any council tax. So there's really no record of them there other than them physically being there. Whether or not they're receiving mail, we're actually not sure. Although I think the client had mentioned that they weren't. Anyway, so that was the only thing that sort of made things a little more complicated than just going straight to the police. And so in this case, because it's a residential property, we're going through the interim possession order process because we're doing it within the 28 days that she's become aware of it. Now that's where things get a little bit complicated because they've got a lot of documents related to the home in the home. So things like the title deed that we needed to get that prove it's in her father's name. Obviously, they don't have physical access to that, so we've had to complete, which you will know, about the form OC2 just to get the original copies of those documents, the proprietorship register, those sorts of things. That way, that if she does end up going to court because they dispute the interim possession order, she's actually got hard evidence that it's never been transferred out of her father's name and into someone else's. In this case, the landlord, we don't even know if the landlord's a real person, unfortunately. We couldn't find a record of him. So, you don't want to assume people are lying, but it's quite common in this sort of situation that the illegal occupier is the lying party. So then you've got to determine if they're unlawful. In this case, that's the process we're going through. There's two claim forms, or rather, there's a claim form and a form of notification that you serve on the occupiers to remove them, which we have helped the client to complete. That's the N5 form, which is the claim for possession form, and the N130, which is the interim possession order form. Then once you've submitted those to your local county court, which you should normally choose one quite close to the property, you'll be issued with the documents from the courts, and the courts will actually tell you in those documents by when you need to serve it on the occupiers, which is the stage that we're at now. So now, having done this a few times in the past, from there, there's just a form of service and a few other things that would happen. But at this point, would you say you've got any questions about?
Not as yet, but I was actually not really worried, no concerned, but I'm wondering, because there wasn't any record about this landlord, you guys, what happened then? Like, how do you prove if they're lying or not? Like that situation.
Yeah. Okay. So good question. Obviously, so from
Because
the
also
client's perspective,
paying,
yeah, go ahead. Go ahead.
sorry, no, because I'm thinking because also they were paying cash, and like you
Mm.
mentioned, there weren't any utility bills being paid or anything like that. So then how do you prove to the court that they have, well, they are lying, there isn't really a landlord that they're paying, or that the tenancy agreement really is, invalid or something like that?
Yeah. No,
What was the
excellent
process there?
question. Yeah, perfect. So obviously there's a couple of things that the clients have to do to prove that they do still own the property. And so the land register is one of them,
Okay.
but they're going to attach a driver's license to prove the identity of the father, who's the owner.
Oh
They're
yes.
going to attach utility bills, council tax statement, mortgage statement. They've even got the original purchase agreement. So those things help them prove they're the owners. And then the burden of proof falls to
Oh,
the
okay.
occupiers to say, oh, but they authorized this landlord, or not the landlord, rather, or the agent, or whoever they're claiming is renting it out to them. They authorized so and so to rent it out to us. Which is where it could get a little bit complicated, because if someone is genuinely renting it out to them, pretending to be the owner, it gets a bit more complicated from that point, because they would be seen as living there under the impression they have a tenancy, rather than lying that they have a tenancy.
Okay.
And yeah, so that obviously makes it a little bit more complex. In this case, because they're paying cash and because there's no record of their tenancy other than a contract that they could have drafted themselves, it's quite possible that there is no person renting it out to them, right? And for them to
Mm-hmm.
prove that that's not the case, they would need to, call the landlord that they're renting from to the court. If they're going to dispute it, he'd need to be proved to actually exist. So that burden of proof rests again with the occupier. So it is a good question, but it's not something we're particularly worried about. I mean, worst comes to worst, this guy really, there really is a guy that's renting it out to them, even though he doesn't own it. Um, in which case they don't really have a tenancy, but then there's a whole different process to removing them, and obviously you can go back to that guy for some sort of compensation claim. In this case, we don't think that's going to be the case. All right, yeah, so good question. From there, the courts are going to issue the forms back to the client. It's going to say by when she needs to serve notice on the clients and how. Normally, it needs to be posted up on the wall on the property. I've seen some people say you can put it on the stake, but probably the safest is to push it through the letterbox, stick it up in the front door, something like that, and just make sure that it's in a clear folder, so that it's obvious what it is, rather than a completely closed, unclear envelope. So that's just what happens there. It also comes with the defense form, which the court provides, so that the occupiers are allowed to complete what would be basically like a witness statement, where they would say, okay, well, this is what we say. They also need to say that that's true. So they do risk perjuring themselves if they end up lying. And from there, if it does go, the courts are either going to take that witness statement and what they've already issued and what they've already received. Um, sorry, when posting those two forms on the door, as well as the defense form, Mary should also, not Mary, the client should also be posting any supporting documents. So those things we mentioned, utility bill, driver's license, mortgage statement, should also
Yeah.
be submitting those. So I mean, at that point, that would make a reasonable person fairly aware that this person can prove they own it. Because obviously, playing devil's advocate, an unlawful occupier could be
Yeah.
staying in a place and someone that's not the owner could tell them to leave. And so maybe it helps that they know this is really the owner as well. From there, they either have
So
24 hours. Yeah, sorry, go ahead.
mhm. No, I'm sorry. You can go ahead. I'll ask after. That's fine.
Okay. So from there, the courts will either make a decision giving the occupiers 24 hours to vacate the premises, or will go to a hearing, and then both parties will have the opportunity to make their case. It's very unlikely that it would get to that stage, because the current occupiers would need to give a little bit more than what they currently have to prove that they've got a right to be there.
Oh, okay. So then I want to ask the claimant, the only thing she wants is for the squatters to, vacate the premises. Is that it? Because are there no
Correct.
damages made? I mean, they've
Yeah.
been staying there for a good time without the claimant's knowledge. Is that the only thing that she's requesting, that the squatters, vacate, or is there more?
No, so in this case, they're not going for any damages, but if there were damages, then they could do that. It's part of the same process potentially, but that's not what they're doing in this case, just because it's not relevant. I mean, it's also just from a practical point of view. In this case, they've not been there for 12 months, so they'd need to prove that the squatters currently there are responsible for the damage they're claiming for, whereas it could be someone else entirely. So, if they had CCTV or something like that, then it'd probably be easier to prove. But if they had CCTV, they'd also probably have been aware of the squatters' presence much, much earlier. So yeah, there is a process for that, but it's not relevant to this client.
This time, yeah, makes sense. Okay.
All right.
Yeah. Sorry, no, go ahead, Joshua.
That's actually it. I think the only thing I didn't touch on was just that there are court fees when you're submitting these documents. And we've had some clients that prefer to post it, some clients who prefer to pay online, and some who prefer to have the courts phone them and then they make the payment with their debit cards or credit cards. That's the only thing I haven't mentioned. Otherwise, I think we've covered the broad strokes of the case, and I won't prattle on about it too much longer. So yeah, if you have any final questions, we'll go through that, and otherwise I think we'll crack on.
Yeah, no, I think everything makes a lot of sense. Yeah, if anything else comes up, I guess I'll ask.
Okay, perfect. Yeah, so that's all for today's weekly discussion. We'll obviously try and do this again next week, and yeah, thanks for joining me.